Thank you for joining us once again on another exciting episode of the Law Gallery, coming to you from the Lagos studios of KAFTAN Television. Khalid, Bada is my name. And as you know, I don't do this alone. I always have a brilliant legal practitioner with me who will be joining in the discussion of legal issues surrounding the rule of law in Nigeria and the practice of the legal profession in Nigeria. But before we go into the discussion, I have Esther on standby, Esther Agu, for the relay of the news updates on the program today. We'll be right back.
Thank you, Khalid. Once again, I'm Esther Agu. On the news today, the Nigerian Labour Congress, NLC, has threatened to embark on a nationwide indefinite strike from August 14. If at the close of work on Friday, August 11, the contempt charge against it by the federal government was not withdrawn. Recall that the Federal Ministry of Justice had gone to court on Wednesday to file a contempt charge against Labour and the NLC and Trade Union Congress, TUC, for embarking on strike. At its National Executive Council NEC meeting to review Wednesday's nationwide protest, NLC demanded indefinite withdrawal of the contempt charge. A communique issued at the end of the meeting said NLC leaders also gave reasons for suspending the nationwide protest, noting that NEC members deliberated exhaustively on the mood of the nation amid the suffering and deprivation across all the states of the Federation. According to the communique, NEC also reviewed the effectiveness of the nationwide protest, particularly the meetings with President Bola Tinubu, the leadership of the National Assembly, and the contempt charge action of the federal government through the National Industrial Court of Nigeria. The communique signed by NLC President and General Secretary Joe Ajaero and Ima Ugboaja, respectively, Bola Tinubu responded through a closed-door meeting with the leaders of the Congress and Trade Union Congress, TUC. Concrete agreements were reached and the President personally guaranteed action on the following areas: commitment to an immediate restructuring of the framework for engaging the consequences of the PMS price hike in the line with input of the labor leaders. On to the next. Senior lawyers have stressed the importance of justice for all as they gathered to deliberate on the ongoing debate about freedom association. The legal practitioners, including members of Nigerian Bar Association, NBA, came together to advocate that justice be accessible to every individual, regardless of background or affiliation. The advocacy was made during the first annual General Conference of the Nigerian Law Society with the theme Justice for All. The conference delved into the intricacies of statutory professional regulations while emphasizing the need to uphold the fundamental right to freedom of association without compromising the principles of justice for all. Amid spirited discussions, legal professionals rallied to affirm that commitment to justice for all, emphasizing that the right to freedom of association should not infringe on the rights of non-members of association like the NBA. The Nigerian Law Society's conference served as a platform to foster unity among legal practitioners and promote a balanced and progressive legal society. The determination to ensure justice for all resonated throughout the event, with participants recognizing the significance of collective action in driving positive change within the legal profession and the broader society. On to the next civil society organization, the Coalition for the Protection of Democracy has won the lead counsel of President Bola Tinubu at the Presidential Election Court, Chief Wole Olanipekun, Senior Advocate of Nigeria, to stop harassing the judiciary. The group spoke amidst criticisms that greeted the position of Olanipekun at the PEPC, where he submitted that there could be anarchy in Nigeria if the election petition court nullified Tinubu's victory. Tinubu had asked the Presidential Election Tribunal to dismiss the petition filed by Labour Party seeking to nullify his victory on the grounds that he did not secure 25% of the lawful votes cast in the Federal Capital Territory, FCT. Tinubu, through Olanipekun, in a final written address to the tribunal against the petition, said the FCT is the 37th state of electoral purposes and any other interpretation would lead to absurdity, chaos, anarchy, and autocration of the very intention of the legislature. But caught them at a press conference in Abuja, described Olanipekun's submission as a threat to the judiciary. The group spokesman Danjuma Garba Musa, who read the speech, alleged that Tinubu's counsel's submission was capable of intimidating the justices of the appeal court handling the case. And that will be all for the news update for today. Back to you, Khalid.
Welcome back. It's still the Law Gallery coming to you from the Lagos studios of KAFTAN Television. And before we went on the break, I mentioned to you that I have a brilliant legal practitioner who will be joining me in the discussion today. Today we'll be talking about the ethics of the legal profession. You know, there are moral conducts to every profession, and today we'd like to know, you know, the ethics guiding the legal profession, particularly the attorney-client relationship. Now, let me start the discussion by quoting Ibrahim Abdullah, 2014. It says, legal practice is a very serious business that is to be undertaken by serious-minded practitioners, particularly as both the legally trained minds and those not so trained also learn from our example. We, therefore, owe the legal profession the duty to maintain the very high standard required in the practice of the profession in this country. Ethics demands from a lawyer that his client must have absolute confidence in him. Ethics demand that he knows his duty to the court. Now, with this quote, I'll be opening the discussion today, and I have with me Barrister Ogechi Ngbaka joining us in the discussion. Thank you for joining us. Huh?
Thank you for having me. It's a pleasure to be here again.
Oh, yes. I remember you've been on the Law Gallery once.
Yes.
Thank you for joining us once again.
It's my pleasure.
Now, let's just go into the discussion. Now, I read out from quoting Ibrahim Abdullah, 2014, in an article mentioning that ethics demands from a lawyer that his client must have absolute confidence in him. Ethics demands that he also must know his duty to the court. Now, ethics can be perhaps seen as a legal or a guide or a code of conduct. Are these ethics actually learned in school, or they are just something that you build up over the year? I just want to know, because now we understand that there are ethics to every profession. The ethics of the legal profession, is it like perhaps a course in maybe the undergraduate level or the graduate level, or is it just an innate conduct to the profession that everybody just knows?
All right, thank you for that question. Well, ethics in the legal profession speaks to both the duty as well as the skill of a legal practitioner. And of course, by training, we are meant to imbue these qualities, the skill that is required of you to practice as a lawyer, and of course, the duty that you owe to your client as well as other persons involved in your practice of law. You are meant to undergo the training in school, and of course, at the law school, we have a particular course dedicated to ethics. That is law in practice, as it's currently called. So that course focuses majorly on legal practice, the ethics, conduct, professional misconduct, and all that is required of you in your practice as a lawyer. So by training, yes, and it's also required that by virtue of your practice, you need to exhibit this conduct required of you as a legal practitioner.
Now, these ethics, I understand that there are different, it's a broad spectrum, it's a broad concept. There are ethics in the court, there are ethics as to clients, or perhaps how to even handle things. Now, are there different ethics? I understand that there are different specializations of law. We have the criminal lawyers, the property lawyers, and now are there difference there, or it's just a general thing to everybody?
Okay, your practice as a legal practitioner, we have ethics that guides the practice, irrespective of the area of law you decide to branch into. The rule applies to all
Everyone.
and sundry. However, there are specific field requirements expected of you in the area you are practicing at. So you are expected to also exhibit outside of course the general practice. You are expected to exhibit the specific qualities required of you practicing in that particular field. Yes. So, for example, someone who is a criminal litigation lawyer has a set of duties expected of him in handling his clients who is a defendant in a case. A lawyer who is acting for a company, a commercial practice and corporate advisory, also have code of conduct that applies to him. And in this instance, the code of corporate governance will of course apply to him, and other area practice specific rules that applies to specific areas will you are expected to abide by those as well. So aside of course the general rule, ensure that you are up to date, you are abreast with what is required of you in your specific field of practice.
Now, could you outline some of the general ethics of the legal profession to us?
Okay, broadly, we are majorly aware of the duties required of you as a legal practitioner. Well, if you look at the legal practice in Nigeria as it currently constituted, is such a way that most of the focus is on litigation, because that is the mainstay of the practice. So there's no way you discuss professional ethics without having litigation as the main focus. And as such, the general requirement, now the relationship of a lawyer and a client is fiduciary. What that means is you are expected to act in utmost good faith. You have to represent your client to your utmost ability. However, your duty to the client is not, of course, the highest duty you owe as a legal practitioner. Your highest duty is to uphold the rule of law. So however, when you are representing your client, it must be within the bounds of law. So you have a duty to act in utmost good faith towards your client. You have a duty to not engage in any conduct that will bring disrepute to the profession. You have a duty to represent your client to the best of your ability. You also have a duty to, apply utmost skill in representing your client's cause, either in court or any other matter.
Now, you mentioned that as a legal professional, you are expected to represent your client to the best of your ability,
Yes.
and you are also obliged to uphold the rule of law and the rule of the courts. Now, how do you strike a balance between the client and the court? Taking for an example, in a situation where the client or the conduct of the client is in opposition to the rule of law or the conduct of the court, how do you strike a balance there? How do you, state out your objective?
Okay, while representing your client, like I said earlier, it must be within the bounds of law. Now, we have what we call a client attorney privilege.
Okay.
What that means is the information that your client tells you by virtue of your position as his lawyer or a lawyer is privileged. However, the law provides exceptions where those privileged informations can be disclosed. One of those instances is where an offense is going to be committed, right? In that instance, you are obligated by law, when the circumstances requires, for you to make a disclosure of that information, notwithstanding that it ought to be confidential. So in representing your client, it must be within the bound of law. One, the act must not be illegal. If it is illegal, your duty stops there. if you are required by an order of court judiciously made to make a disclosure, your duty to keep confidence of your client's information will be suspended at that point. So the law is the overriding principle that guides our conduct, irrespective of the fact that we owe our clients these duties to preserve their information, not to go against their wish, not to do anything that will be against their interest, insofar as that is not against the law. So we are navigating the practice, providing the services for the client, you know, keeping confidence of the information, but within
Still
the
in the
scope
confines of the law.
allowed by the law. So anything outside the rule will be suspended.
So you've never had a situation of conflict of interest?
Yeah, there are instances. Personally, I have not encountered such, but there are instances of conflict of interest. So where there's a conflict of interest, that is another example where you... Now, we have one rule, one principle that a lawyer cannot pick and choose who he represents. Now, when someone comes to meet you with a legal challenge, the law expects you by professional conduct to accept the brief, except where there is conflict of interest. And conflict of interest in this instance can be, one, you are related by blood. For example, my client comes to me with an issue, right, to represent him or her. The party he has the issue with is a brother of mine, relative, or we are related. There's a conflict there purely. Or possibly I acted in a judicial capacity prior, and as an offshoot of the current challenge of which the client has presented to me is related to the past matter. So there is a conflict of interest, and several instances. So where there is that conflict of interest present, another instance is where you are interested in a particular property and your client is also interested. For example, let's take Lagos. There is a land that is up for sale. And you as an individual, you are interested, you want to buy. And your client comes to you
and wants to buy such land too.
That he also wants to buy the same property. There is a conflict of interest there. So in some of these instances, the rule that you cannot pick who to represent is also suspended. So conflict of interest acts as a bar as to when you as a legal practitioner can represent a client.
So in a case of conflict of interest, what one does is you drop such case and, you know, probably leave it to somebody else, right?
Yes.
That is an interesting one.
Yes.
Now, the world is a transparent world. There is this case of social media, the internet.
Is the world very transparent?
Yeah, it is. We regard the world to be a global
village.
world, a global village now, where, you know, there is transparency and there is information flying around. Now, how do you maintain confidentiality in such case, where, particularly considering the social media, where you can literally get anything on social media now and people quickly send anything to the social media? There's something happening and it's already on the social media. How do you then maintain confidentiality?
It's a very tricky one, to be very honest. It's a very tricky one. And not only because of the prevalence of social media, even outside that, is difficult. It's quite tricky to be able to maintain confidentiality, but notwithstanding, it is a requirement of the law. Now, where the information is emanating from is important. If the information flying around, supposedly about your client, did not emanate from you, you have not breached the rule of confidentiality. There can be other sources of information. In as much as it did not emanate from you, you have not breached your client's confidence. You breach your client's confidence where information that you ought not to bring into public space, you are doing so. That is breach of confidentiality. I have an instance not too long ago. A colleague was briefed to handle a particular matter for a client, and in the process of the briefing process, some informations about the individual were disclosed to the client, and unfortunately, I'm sorry to be saying this on air, the attorney did something that he ought not to have done. He made a post, and even if people may not outrightly know that this thing is about a particular individual, but for someone like me who is aware of the facts, when I saw that, I knew this was in relation to this particular individual that this lawyer ought to be representing. It ought not to be so, right? You have temptation, especially in this period, you have temptation to make content, garner likes, garner comments from, people. The temptation is there, very obvious. And by virtue of your practice as a lawyer, you get these informations on a daily basis about individual. They are true life stories, right? So, and to be very candid, those are very juicy content for the social media. So you'll be very, very easy for you to be tempted to put it out there, to enjoy the momentary attention that it gets. But that should not be done as a lawyer, right? So it is tricky, but then you have a duty. You have a duty to do that. You are not to, however, in whatever guise, however subtle, don't go disclosing your client's information online or elsewhere at
what if the person just creates a scenario out of it? Perhaps someone who committed theft, for an example. Now, there is a case, there is a real life situation. What if such attorney just creates something like a fiction out of it?
Are you the attorney representing that individual?
Yeah.
However you look at it, somehow it can be linked. It can be linked to the life situation, right? But this is not to say that creating scenario necessarily means that you are alluding to the story about your client. Not at all. But if we look at it carefully, in most instances, there is an underlying interest. This thing is coming from somewhere. And for people who are aware, for example, if the matter is something in court, right, and at that point it has become public information, that's fine. Although you're also not allowed to make some pronouncement while the matter in court. I believe you've had it. It's called the principle of sub judice. When the matter is in court, you are not to go, saying things that will likely affect the outcome of the case, except in those instances where it is public knowledge.
Perhaps the election petition going on.
Yes. But even at that, there's still caution.
Okay.
There's still caution. The matter is ongoing. Allow the court to make their findings, right? The best you have to do is present your facts as it relates to you. Let the court be the one to make the decision, not you. When you go granting interviews and all that to the press about a particular matter, there is every likelihood of you not just stating the facts as it relates to you. You are likely to state the outcome. Now, we can take the election petition, for instance. There are many opinions flying around.
Sure.
And people have already concluded what the outcome will be. A lot of us are going to be surprised by the time the judgment is made. When you look at it closely, we have opinions, and once you have opinion, the opinion will affect your sense of judgment.
True.
Right? So the judge is there to act unbiased. We are already biased, either as a lawyer or a party on any side. We're already biased. So our expectation is that this outcome should be this. If it's not this, it will be unacceptable to us. So we need someone who is unbiased by these opinions to make a finding after comparing both sides, and then come to a conclusion as to which is which. So it is not in the place of a lawyer to go about, talking.
Right. So apart from confidentiality as one of the rights of the client enjoyed from the attorney, are there other rights the client has with the attorney?
Okay, we've mentioned confidentiality. We've mentioned, let me further buttress on this. The lawyer has a duty to represent the client to his utmost ability. Ability in this sense means that you have to bring into bear your skill and training as a lawyer. Now, of course, it is a general notion among us. No lawyer knows all the law. In fact, it is impossible for you to find a lawyer who knows all the law.
Yep.
But a lawyer knows where to find the law. So it is possible for a lawyer to be presented with a scenario or a case that he has not dealt with prior to that time, or a matter that he is unfamiliar with. And what is required of him at that point is to make research. Research is one of the tools that the lawyer needs to, do well as a legal practitioner, is to go and make research and make findings. So that is why he said you know where to find the law. I'll give an instance. Some months back, I was encountered with a matter, a tax matter actually, and sincerely, that was the first time handling such a matter. In fact, while in school, I didn't even offer taxation as a course because it was optional, so I chose something else. That was my first time, so I couldn't tell the client, no, I can't represent you because I don't know this area. No, you know where to find the law. Go and find the law. You have colleagues who are experienced in the field. Meet them, make inquiries. So you representing them to the best of your ability also means going the extra mile. You have to burn the midnight oil sometimes to prepare the brief, to read, to understand the principles that govern the area, so that you know how best or what best strategy to apply in order to ensure that your client gets the best result as possible. So you have to bring in the skill, you have to bring in your intellect, and everything. Just bring it to bed to ensure that
now
you do your best.
there is this notion that every lawyer is a liar. I'm sure you've heard it before. There's a notion every lawyer is a liar. Now, and we've talked about transparency to the client and to the courts. And with this notion that every lawyer is a liar, now you're committed to saying the truth to the court, and you're also committed to defending your clients. Then how do you balance this out?
You see, that is where people miss it, and they say that lawyers are liars. It's not true. And to be very frank with you, it will be hard to debunk that notion, especially when you are speaking with someone who does not have an open mind, right? Now, the instance you gave, you have a duty towards your client. I also have a duty towards the court, and of course to uphold the rule of law. Now, this lawyers are liars opinion that fly around applies majorly in criminal and maybe a few times in civil cases in court. You see a situation where, of course, someone is accused of a particular crime. And, well, let's say to us, the viewers, the person did commit the crime. Now, the court wasn't there where the crime was committed. The court is going to make a finding based on the evidences presented before him. So let's assume the party on whom the duty lies to produce that evidence fails to do so, or fails to adequately provide the evidence that will be enough for the court to reach a finding that convince the defendant, the court cannot do otherwise. You get, the court cannot do otherwise. Now, of course, we know constitutionally a person who is accused of committing a crime is presumed innocent until proven otherwise. So the duty is on the other party who is accusing him of committing the crime. Now, people who say lawyers, as it relates to criminal proceedings, have the accusatorial mindset. Accusatorial meaning that you are assuming the person to be guilty. So you expect him to prove his innocence. But that is not the case by Nigerian law. Nigerian law is saying the person is innocent. So you are expected to prove him guilty. And that has to be proved beyond reasonable doubt, not proved beyond all doubt. So the proof has to be sufficient enough that a neutral party who is seeing the evidence as against the accusation can say, this person committed this offense. That is on one side. On the other side is, you can accuse someone, or someone outrightly may have committed offense A, right? And you are bringing him to court for offense B. There are two different things. The requirement of proving offense A might be different from the requirements of proving offense B. So if he actually committed offense A and you're bringing him for offense B, and thereby providing evidence for offense A, the court cannot convince him for offense B that the evidence was not provided for. So let's say someone outrightly commits the offense of stealing, and you're bringing the person to court for armed robbery, and the evidence before the court does not say that this person committed armed robbery. The court cannot convict him for armed robbery. Of course, the lawyer was instrumental in the proceeding. So by the time they come outside, they say that the lawyer has lied. The lawyer didn't lie. He only acted on facts available. And of course, the judge also acted at facts presented by the both parties. And in this instance, I will say that the prosecution has much to do, right? In the sense that the duty lies heavily on them to produce evidence that is compelling enough that the court can, actually act on. Let's take, for instance, the case of Emefiele. Imagine that kind of charge. You arrested someone and you kept him in detention for that long, and you are producing him in court on the charge of possession of firearms. They do not correlate. They do not correlate. So in that instance, if he is eventually charged for that offense, it is very likely that he will go scot-free. You get, the court will likely discharge him and find him not guilty. But to the eyes of ordinary Nigerians, the lawyers have lied, the judges have lied, and every other person involved have lied. Okay, so that is the misunderstanding. On the other part, and to add to it as well, people fail to understand that we are not gods. We are humans. We have limitations. So do not expect us to do the impossible, right? And fundamentally, when it comes to, as a way of explaining this issue, the question of confidentiality is also comes into fruition, because the lawyer is bound by law to protect his client's confidence, even when your client confesses to you. Of course, in most cases, for criminal cases, your client will, of course, tell you the truth. Now, there are persons that you are not to lie to as an individual. One, your lawyer, your doctor, and maybe possibly your religious leader. You are not to lie to this group of persons, more particularly your lawyer and your doctor. If you lie to your doctor, you might get the wrong prescription.
Now, in cases where a legal practitioner breaches an ethic,
Yes.
is there like a governing body or like the legal police that watches, you know, the practice and, you know,
Yeah.
perhaps the misuse of this ethics?
We have, in your words, legal police. We have bodies that responsible for regulation of conduct by legal practitioners. We have the body of benchers.
Okay.
We have the General Counsel of the Bar. We have the Attorney General of the Federation and of the states. We have the Chief Justice, and the justices of the Supreme Court and the Court of Appeal, and of course the judges of the High Court. And we have the NBA too, and NBA, not just the national body, the states and branch chairmen and all that are all responsible. And of course, among ourselves, we have a duty to ensure that the practice is not brought into disrepute by a colleague. So where, for example, there is a case of breach by a legal practitioner, there are channels, there are things that you can do to, you know, see that the issue is addressed. So you can write a complaint, for instance, as a private individual, you can write a complaint to address to the Chief Judge, if you can reach him, the Chief Justice, the Attorney General of the Federation of the State, the chairman of the NBA, the branch where the issue is, or even to the president of the NBA, or to the General Counsel of the Bar. Or we have legal practitioners disciplinary committee, which handles cases of professional misconduct by legal practitioners. So if there is instance of breach, there are means of addressing those issues.
Thank you very much for the clarification, Barrister Ngbaka. Now, our time is fast spent and we'll have to wrap up the program for today. But before we go, is there anything you would like to tell the audience? Maybe there is that message about this ethics. Just like you mentioned now that you are all humans and you are not expected to perform a super magic or, you know, use one superpower. Do you have any other message?
First of all, the lawyer is not you need to encourage your lawyer.
Okay.
Right? Yes. Encourage your lawyer in the sense that not only in words. You see, there are clients who fail to adequately compensate the lawyer for the legal services rendered. So in that instance, you shouldn't be expecting the best from him or her. So a lawyer should be properly remunerated, and where that is done, then you can have a solid ground that I have paid him enough money and he failed to deliver. And also, the notion that lawyers are liars is not always true. So let's be sure that before we reach such conclusion, we've checked all the facts to ensure that the person actually did lie. Right? So, and in most cases, it wasn't a lie. It was acting based on the facts available. And of course, the judge as well acted on the facts available. So let's debunk those that opinion or notion that lawyers are liars. So we are not.
Thank you very much, Barrister Ngbaka. I really appreciate your time.
It's my pleasure.
Thank you very much.
Yeah.
Now, there you have it. Lawyers are not liars, just as our brilliant barrister has said. They act on facts, and also try to remunerate your lawyers appropriately. A well-fed stomach is a well-fed brain, you understand?
Sure.
So try to remunerate your lawyers well and trust their judgment. And in addition to that, always just trust the facts. Trust the fact. Lawyers work with facts. The judges work based on the facts that have been presented. And there is no super magic anywhere. There is no superpower. And we should just try to trust the Nigerian legal system to do what is best for everybody. With that, we'll draw the curtain on the program for today to return same time, same station. And I remain Khalid. Bada. Bye for now.